Welcome back to Quick Bits. It's an on-the-road edition because I am traveling for a whole bunch of things this week, including some Dave Matthews concerts. But this week, the Commonwealth rested their case in week 8 of the Commonwealth versus Karen Read, and we finally heard from the medical examiner. There is a lot to talk about, so let's get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Before we get into all of the Karen Read updates that you need, the Emily Show podcast this week, I covered the wildness going on in Georgia with the Young Thug trial. There's a lot going on between the judge and the lead defense attorney, and I break all of that down in the podcast, including the motion for mistrial and to remove the judge. It's going to be interesting to see what happens in that case in the coming weeks. Also, Buster Murdaugh sued a number of productions and the distributors, including Netflix, for defamation based on the allegation and insinuation that he was somehow involved with and or killed Stephen Smith. And with the Alec Baldwin trial getting ready to start in early July, there's been lots of motions and there will continue to be lots of litigation. The court held 2 hearings on Friday, June 21st, and I haven't had a chance to cover those hearings yet, but the court denied the state's motion to force Hannah Gutierrez to testify. Judge Summer indicated that she was not interested in having a, quote, trial within a trial, and it was clear that Hannah Gutierrez intended not to testify and repeatedly asserted her Fifth Amendment right, including in pretrial interviews with the prosecution. And Jason Bowles made clear that Hannah Gutierrez does not want to testify in this case, even if she were granted immunity. And really, even with the grant of immunity, what are they going to do? Hold her in custody while she's already in prison? There's not much of a remedy for the court if she refused to testify in Baldwin's case. So the court didn't grant her immunity, and we will not be seeing Hannah Gutierrez Read testifying in person in Baldwin's case. That doesn't mean some of the previous statements she made won't come in, but we will have to wait till that trial gets underway in July. Speaking of the trial that's underway now, let's talk Karen Read. The Karen Read case is quickly coming to a close, which at points felt like it was never going to happen. It seems that the defense only has 3 witnesses left, and that will probably be done on Monday. It's my expectation that on Monday they will finish the defense witnesses. Then the attorneys will do the legal work that is required to make sure the jury instructions are ready and do closing arguments on Tuesday and send the case to the jury sometime on Tuesday. I think this case will probably have a fairly quick verdict, but we will see. And if you want to stay in the loop with everything that's going on with that case and the witnesses that are testifying and closing arguments, make sure to download the Lawnerd app at lawnerd.com or in the iOS or Android store. I'm going to remind you about it every time we're in trial. And if you're getting ready for the Baldwin trial, now is the time to get the app for notifications when stuff happens in court. So as we are now done with the Commonwealth's case at the end of week 8, after 68 witnesses, there are some takeaways for me from the evidence this week that I'm going to tell you about right at the end of my summary. But take a minute and think about what you still remember, either from opening or the things that stick out in your mind the most in this case. At this point, it's been a lot of evidence. 68 witnesses is a tremendous amount of testimony, and we will see how effectively the prosecution is able to summarize that in their closing arguments. And maybe we got a little sneak peek of that when they did arguments at the end of the Commonwealth's case. On day 26, Monday, June 17th, Trooper Paul was on the stand. He is the Commonwealth's accident reconstructionist. He works for the Massachusetts State Police. And his expert opinion is that the accident occurred at 34 Fairview. Karen Read hit John O'Keefe when traveling 24 miles per hour backwards straight for 62 feet. The right rear of the vehicle struck John O'Keefe, and he was projected forward and to the left. The car continued in reverse and then left 34 Fairview. On cross-examination, he was asked things like, well, if you've said that when there are vehicle pedestrian collisions and the things people are holding tend to go flying off of them, hats, glasses, things in their hands, phones, how did his phone end up under him? And the response from Trooper Paul was, it just did. So there was a lot of that in this cross-examination of, well, there's not really an explanation for it. That's just what the evidence shows. Alan Jackson asked this trooper about confirmation bias and if he understood what that meant, and then gave him a definition, and his response to that definition was, okay, if you say so. So it was a bit of a battle on cross-examination. And the thing that was important for me is that it centered around where the victim's body was found. And that information came to Trooper Paul from Lieutenant Gallagher, who was not on scene while John O'Keefe was on scene. So it was interesting to see that all of the information is kind of based off assumptions from information from like third hand from other people. They also talked about how the taillight would have scratched John O'Keefe's arm, which was testimony from the previous week's testimony. And the trooper testified that the taillight shattered when it hit John O'Keefe's arm. But what we know is with John O'Keefe's arm, there is no bruising, there are no broken bones, there don't seem to be any internal damages. It is the scratches on the arm only. And then there was lots of conversation about the key cycles, and it seems that Trooper Paul did not really have an explanation for how the key cycles line up. That's all based on assumption because the key cycle data does not have dates, does not have times, and the cycle numbers, as the defense walked through it, don't seem to line up with what we know the Lexus did. So are there enough key cycles in between those key points to really show that the backing up of the vehicle happened at 34 Fairview? I think the cross was effective in leaving a question of, is that exactly what happened at 34 Fairview? On redirect, Lally tried to close that loop by talking about cell phone data that showed a 3-point turn before Karen Reed got onto Fairview, and then showing that same information tracking on the key cycle data that seems to show a 3-point turn. But Trooper Paul's initial testimony was that it was a U-turn. But is that consistent with the cell phone data of Karen Reed's vehicle turning around and then getting to 34 Fairview? And if it is, then that makes it a little easier to pin down that rapid backing up for 62 feet to when Karen Reed was leaving 34 Fairview. And finally, the Commonwealth asked again, how is the data from Karen Reed's car consistent with a pedestrian strike from a motor vehicle? And he said it's because there was that drop in speed and a steering wheel shift. The Commonwealth's 65th witness was Ian Whiffen from Celebrate, again talking about Jen McCabe's Google search and the fact that the time on that was from the movement of the tab and when the tab was brought to focus, not the time of the search. And he stated, in fact, Celebrate has changed the way they do those reports so that the timestamp on that is not misleading. At the end of his testimony, he did a demonstration with the jury of how that data logs when you pull the tab up and then do a search. But if the tab is open until the tab is closed or until the program is closed, it won't record a timestamp. But it's a lot of testimony about that Google search. And it doesn't stop there because witness 66 for the Commonwealth was Nicholas Guarino, who is a Massachusetts state trooper and did all of their cell phone data extractions and evaluations. During the beginning of his testimony, he started getting into the text messages sent between Karen Reed and John O'Keefe showing that they were arguing and they were having some disputes over, again, how to best take care of the niece and nephew. And John O'Keefe had indicated he was tired of being the bad guy. And Karen Reed is like, yeah, but I didn't expect to be fighting over parenting with you, essentially. In those text messages, we saw a lot of concerns from Karen Reed that John O'Keefe was over the relationship or was interested in someone else. Moving on to day 27, Tuesday, June 18th was an entire day. Well, it was a half day of court, but it was a day of voir dire. Outside the presence of the jury, the court heard testimony from 3 witnesses that the defense was seeking to bring in and the prosecution was seeking to exclude. The court didn't rule on that until Thursday, and of course, Wednesday was the federal holiday for Juneteenth. On day 28, Thursday, June 19th, the court ruled early in the morning on those voir dires and is going to allow all 3 of those defense experts to testify. So as they testify before the jury, I'll be breaking down their testimony. The court indicated that they may limit the testimony of one of those witnesses, and the court had heard from Dr. Russell, who is going to testify about the injuries on John O'Keefe's arm, Daniel Wolf, who is an accident reconstructionist, and Dr. Rentschler, who is a biomechanical engineer. Dr. Daniel Wolf and Dr. Rentschler both were hired by the Department of Justice in the investigation that the feds are doing into this case. The court indicated that they may limit Dr. Rentschler's testimony because the court believes that only medical doctors can testify about the cause of injuries in Massachusetts, which is interesting because that's not what the coroner, a medical doctor, seems to think. So we'll see if there's more argument on that. I bet that there will be. As the day resumed in front of the jury, witness 66, Trooper Garino took the stand again to go through the rest of the data from the victim's phone and voicemails that the defendant left on the victim's phone. It went through John O'Keefe's step data and location data, showing that John O'Keefe's phone arrived at 34 Fairview, and then at 2:24 in the morning, the phone stopped moving and stayed outside near the flagpole fire hydrant and had no movement until 6:15 a.m. when we know it was recovered from Carrie Roberts. He also testified that the GPS does not show any GPS points inside 34 Fairview for John O'Keefe, but that John O'Keefe's Apple Health data does show that he ascended or descended 3 flights of stairs between 12:21 a.m. and 12:30 a.m. The defense expert does narrow down that timeline, but we'll get there. During direct, that witness was talking about the potential for the phone to show the 3 flights of stairs even if steps were not taken, and that something else or other movement could have caused that, because the Waze data from John O'Keefe's phone shows that he was in the car still traveling to 34 Fairview and more than a half a mile away at the time that that step information registered, which became a key point in cross-examination when the defense was asking if there are multiple different clocks that the iPhone uses, and could Waze be using a different clock that was 3 minutes off, which would change when the Waze data was being used, or at least when it registered or showed at the time. And that, again, will come up more with the defense expert, but that's what the defense is insinuating here, is that the Waze data time is not reliable, so the step data didn't necessarily happen when John O'Keefe was in the car a half a mile away from 34 Fairview. Then we got into the last 2 witnesses. Witness 67 is Dr. Stonebridge, who specializes in neuropathology. So after the autopsy, she received just John O'Keefe's brain and looked at the injuries to John O'Keefe's brain specifically. She indicated that it was her expert opinion that the mechanism of injury was some type of blunt force trauma to the head, unknown what type or how much, and it is consistent, in her opinion, with a fall or with being struck by a vehicle. Remember, it is the job of the prosecution to prove to the jury that there was only one reasonable explanation for what happened to John O'Keefe, and that reasonable explanation, beyond a reasonable doubt, is that Karen Reed hit him with her vehicle. The jury instruction reminds the jurors that if there is more than one reasonable explanation, one that points to guilt and one that points to not guilty or innocence, then the jurors must pick the one that points towards innocence. So when the experts are testifying that there are multiple reasonable explanations for his head injuries, the Commonwealth is going to have to clear up that this is a fall because he was struck by a car, not just because he fell. There was no cross-examination of that witness by the defense, and witness 68 is Dr. Scardi-Bello, who is the medical examiner that performed the autopsy in this case. Of interesting note, that examiner doesn't normally work at the location where John O'Keefe was brought, but was filling in because they were short-staffed. This witness was asked by the Commonwealth if she felt intimidated by Trooper Proctor when they had conversations about this case, and she said that she did not, that information did not change her opinion, which is that the cause of death is blunt impact to the head and hypothermia, and that the manner of death is undetermined. She indicated that it's undetermined because it's between either a homicide finding or an accident finding, but she could not determine which one it was. She indicated that the victim's blood alcohol content was a 0.21, and then went through the autopsy diagrams indicating the other injuries to John O'Keefe, including the small tear on his eyelid, scrapes on his nose, the large laceration on the back of his head, and a laceration to his tongue and the skull fractures. They did not get into the autopsy photos with the jury at the end of the day. Day 29, Friday, June 20th, resumed with the direct examination of the medical examiner. Interestingly enough, after they got into all of the autopsy photos and the rest of it, the Commonwealth asked if the injuries are consistent with a vehicle versus pedestrian collision. And the medical examiner said, quote, "They're not classic injuries with a collision." And then went on to explain that you're generally looking for some injuries to the legs where the vehicle had contact with the victim, and you're generally looking for bruising at a minimum. It was very interesting that even when the Commonwealth was trying to say, but it could be multiple things, that the answer was still, yes, it could be multiple things, which does not help them make their standard of beyond a reasonable doubt, in my opinion. In cross-examination, Miss Little went through where there were no injuries to the victim. Essentially, no injuries to his shoulder, his chest, even though there were 2 small rib fractures near the sternum that the medical examiner said were consistent with performing CPR, which we know was done quite a lot in this case. No other injuries to the torso, abdomen, legs, knees, feet, nothing. The head injury and the injury to the arm. When asked about the cause of those injuries, the medical examiner said, I can't tell you the cause. The back of the head was blunt force trauma, but it could be any blunt force trauma. And then said, I am not a biomechanical engineer, which I think the defense will use in arguing that the biomechanical engineer is exactly the right person to testify about the mechanism of injury, not just that it's blunt force trauma to the back of the head, which the ME very well covered as a cause of death. The medical examiner also testified under cross-examination that the injuries could be consistent with a fight and could be consistent with a fall, and it's possible that they are consistent with an injury from a baseball bat or an injury from a barbell. And then the Commonwealth rested and we got into motion argument. Thank you to today's sponsor, Green Chef. If you've been wanting to try a meal kit, now is the time. Summer always gets busy, especially if you're spending your days watching Trial with me, and Green Chef delivers fresh ingredients directly to your door with over 80 weekly menu items to choose from that will fit any lifestyle, from keto and paleo to protein plus to vegan and vegetarian, gluten-free, or just more balanced meals. Green Chef comes with easy to read instructions and everything you need to make delicious meals easily. So if you are ready to find out for yourself why Green Chef is the #1 meal kit for eating well, go to greenchef.com/EmilyBaker50 and use code EmilyBaker50 to get 50% off plus 20% off your next 2 months. That's greenchef.com/EmilyBaker50 to get 50% off plus 20% off your next 2 months. Thank you, Green Chef, for being a sponsor on this episode and for making sure I have dinner while I'm in trial, because that's what we've been eating this summer. Let's get back to today's episode. With the motion argument, Alan Jackson argued the directed verdict motion or judgment of acquittal. The standard for that motion is that the court must view the evidence in the light most favorable to the Commonwealth and must determine that no reasonable jury could come back with a verdict of guilty. Alan Jackson focused his argument on one of the key elements to all 3 of the different charges against Karen Read, which is Karen Read struck John O'Keefe with her car. Each thing she's charged with is predicated on her striking John O'Keefe with the car. And he argued that there is no evidence that Karen Read struck and killed John O'Keefe, and the state's entire case rests on Trooper Paul. And Trooper Paul's conclusions are conjecture, and that even the medical examiner doesn't believe this is a homicide, and the injuries are inconsistent with a motor vehicle versus pedestrian collision. The Commonwealth argued that their case does not rest on Trooper Paul, that there is evidence at the scene, including one sneaker at the curb, the drinking glass near the victim, the microscopic taillight embedded in the victim's clothing, and the road evidence around the victim are all consistent with the crash, plus the defendant's statement, I hit him, I hit him, I hit him. The court didn't even take a break and very quickly denied the motion, which is not a surprise given the standard of this motion. It is a very hard standard for the defense to meet if there is any evidence that points to this could be a motor vehicle collision. Of course, that's not the standard the jury will have to consider. And then we got into the defense case. Their first witness was Brian Laughlin, who is a plow truck driver who knows the Albert family and had delivered pizzas for Chris Albert, and talked about when he started his route and that when he was circling back around to Fairview between 3:15 and 3:30 in the morning, he saw a light-colored Ford Edge outside of the Albert home near where the flagpole and fire hydrant are. A, he noticed it because it's the Alberts and did not call it into his supervisor as a courtesy to the Alberts, but B, vehicles are not supposed to be parked on the roadway in snowstorms. It is a roadway hazard, so it was very noticeable to him that that vehicle was in the roadway. He also talked about having a very clear view from his snowplow and passing Fairview numerous times and not seeing John O'Keefe on the lawn. On cross-examination, there was some confusion about the timing of when he passed 34 Fairview, but even with the confusion and the timing, it was clear that it was after 2 o'clock in the morning and before 6 o'clock in the morning during the period of time when, if the Commonwealth's theory of the case is correct, John O'Keefe would have been on the lawn at 34 Fairview, and the snow wasn't super heavy yet. The second witness for the defense was Dr. Russell, who testified to an extended resume that includes research into police and canine dog bites because she treated them as an ER physician, but she has also worked as a coroner. She has a very unique background that is really interesting given the facts of this case. She testified that the injuries on John O'Keefe's arm, in her opinion, are from dog bite and scratch marks, and that the positioning of those injuries indicates that they are a defensive wound. The most interesting part of her testimony for me came out on cross, and I say that because we had seen her in voir dire, and her testimony and background was very interesting. But on cross-examination, the prosecution asked if it could be discerned how long those injuries would have occurred before death, or if they occurred before death. I said that more concisely than I think Lally did, but her testimony was that they would have occurred before death, but not long enough before death for the body to have an inflammatory response around the injuries, and that they were consistent with a large dog. Not having enough time for the body to respond to the injury is a very interesting bit of information of how close in time that would have happened, and that it happened before the death of John O'Keefe. But we also heard from the medical examiner, and I don't remember if I mentioned this earlier, concert brain, that John O'Keefe's head injury was not immediately fatal. So he could have been incapacitated and still alive for quite a while, and the hypothermia was a significant aggravating factor, and that is why it's one of the causes of death, because he was not able to get somewhere warm or seek medical treatment for the head injury. The third witness for the defense is Richard Green, who is their digital forensic expert. He testified about the Google search from Jen McCabe, and that it's his opinion that that Google search happened at or before that 2:27 a.m. time. He also talked about the Apple health data from John O'Keefe, saying that the iPhone registers stairs when you were going up the stairs, and that that is incredibly difficult to replicate by just moving your phone around or changing the elevation of the phone, that those things don't replicate stair data, which could either be ascending or descending stairs, and that based on a granular look at the phone, that stair data changing of 3 flights of stairs would have happened between 12:22 a.m. and 12:24 a.m. And he raised the issue of the different clocks used by the iPhone, and that it needs to be looked at because one of the internal clocks was 3 minutes off from the others. So the Waze data doesn't necessarily exclude the stair data because they are not necessarily happening at the same time. They could be happening 3 minutes apart, but that was a question raised, not an answer given. However, for the defense experts, questions raised are their entire purpose, because questions raised are potential doubt for the jurors. I think Lally did a pretty good job at cross-examination of this witness. Some felt it was a bit aggressive, some didn't, because the witness did have moments of, well, I'm not really sure about that. And yes, it could be this. And yes, I agree with the Commonwealth experts on that. Most of the cross-exam, again, was about Jen McCabe's Google search and the predictive search terms, and whether the predictive search terms indicate that she had not searched "How's long to die in the cold" before 6:23 a.m., and that this witness could replicate that when you started doing how long to digest food came up when you hadn't searched anything before. They also talked more about those internal clocks, but after the testimony of the coroner in the morning that the injuries were inconsistent with a motor vehicle collision, it was difficult for me to sit and listen through this digital evidence and fighting over Jen McCabe's Google search, because at that point, you haven't told me how John O'Keefe was hit by a car. So I don't know if Jen McCabe's Google search is the key point here that needs to be focused on by the Commonwealth, but we'll see what happens in closing arguments on Tuesday. I hope to see you live over on YouTube. I know the quick bits have gotten a little less than quick, but we'll be back to normal quick bits soon. Well, Emily, don't promise that. The Baldwin trial is about to start. Make sure you're ready for both by downloading the Lawnerd app, and I will see you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.